There are still many parts of the cannabis market that feel unregulated, and intellectual property rights is one of those areas. And with the US cannabis market expected to reach $26 billion by 2025, it's of extreme importance that all cannabis operators protect their IP, from proprietary cannabis strains to branding to design and technology. This is an increasingly competitive market, and it demands that operators protect their hard work with patents, copyrights, and trademarks. Now, in this video, I will help you understand the different parts of IP protection and how you can begin to establish the right safeguards for your cannabis company. But before I do that, I need to let you know that the information contained in this video is meant for guidance purposes only and not as professional legal or tax advice. And further, it does not give any personalized legal, tax, investment, or business advice in general. So with that, let's hop right in. First, what qualifies as intellectual property? Well, IP refers to trade secrets, or most simply, an entrepreneur's right to protect his or her original work. The most recognizable forms of intellectual property are patents, trademarks, and copyrights. So let me define each and every one of these for you. First, patents are the exclusive right to make, use, or sell an invention over a certain period of time. And trademarks are the exclusive right to use a mark, a logo or otherwise, in business with specific goods or services. And copyrights are the exclusive right to copy and make a derivative of or distribute or publicly perform an original work. So what qualifies under IP rights can vary, and the conflicting regulations of the cannabis market can be difficult to discern, what you should actually protect. So next, I want to cover some of the standard best practices that cannabis entrepreneurs should follow, specifically when it comes to actually protecting your brand, the technology, the cannabis strains, and your business secrets. First, let's talk cannabis branding and trademarks. Now, since cannabis is still considered a Schedule I drug, trademarking your brand is a little bit complicated here, okay? Federal trademark protection can only be sought for something that is considered lawful use in commerce, all right? So because cannabis is still federally illegal, a federal trademark on cannabis is illegal. So to get around this, many cannabis entrepreneurs are filing trademarks on ancillary services or products in the meantime. So protect your cannabis-related products, such as those that support your cultivation, consumption, or sale of medicinal cannabis. Another strategy is to file an ITU that claims your intent to use a trademark in legal commerce in the future. And since ITU applications can last for up to 3 years, many entrepreneurs are betting that the federal government will legalize cannabis at the federal level within that time window, thereby converting their commercial activity to a legal use in commerce. So this will actually effectively protect their trademarks in 3 years. So without a doubt, cannabis entrepreneurs should at least file minimally a state level trademark for their brand. Now, many states permit some form of trademark registration even when commercial cannabis is not legal yet. The one drawback to a state level trademark registration is that it's only enforceable within that state's borders. Now next, all cannabis businesses should file for a logo copyright. All right, copyright registration can really help protect the brand as this industry continues to mature and grow. And you can register a copyright with the US Copyright Office for around $55. It's not expensive, but it can save you a lot of headaches in the future from someone ripping off your brand. Now let's talk about cannabis technology and patents. So cultivators who are interested in patenting their technology can do so with the US Patent and Trademark Office, which is for short the USPTO, all right? And a utility patent will protect your invention and exclude others from making, selling, or using it without your explicit permission for up to 20 years. Now, some of the technology or equipment in a cannabis business that you might want to protect is going to be growing apparatuses, cultivation methods, extraction techniques, chemical compositions, smoking and vaping products, software, and cannabis plants. To qualify for a patent, the USPTO will look at your application to make sure that it meets 4 general criteria. So the first one is that the invention must be statutory, it must be legal. Number 2, the invention must be new and novel. Number 3, the invention must have a use or a purpose. It must be useful. And number 4, the invention must be non-obvious to someone who has a ordinary skill in the art of what you're doing. So these patents can be expensive, around $8,000 all the way up to $50,000. And this depends on how many office actions you get back between the USPTO and how many hours that the lawyers have to do for claim construction and all these different nuances to it. So, and there are certain different provisions you must meet around when the invention is used publicly for you to actually make a utility patent application. I would highly suggest you reach out to a patent lawyer to find out what those little provisions and nuances actually are. So we've all seen it before, DIY law, LegalZoom, all these other things, right? They can help you write your own patents to help save money, but let me give you one little tip on patents. Enforcement of your patents and of your rights. You can't just write a patent and say, you can't do this anymore. You have to enforce it all the time. And people can steal your stuff, but you have to go out there and tell them, no, you can't do it. So enforcement really comes down to how well your patent is written. Okay, sometimes a few misplaced words in your formal claim language can make your patent not even worth the paper that it's printed on. Also, patents can be re-examined by the USPTO even after they've been granted. Sometimes prosecution, it goes really smooth, but the examiner misses some type of prior art for consideration, and now your IP rights are in limbo. It happens a lot more than you're actually gonna, expect, but it does happen. So, if you're going to use patents as a defensible mechanism and competitive advantage in your business, then make sure you seek out a law firm that has written many patents, especially ones that have been used to win litigation. Next, let's talk about cannabis strains and plant patents. So there are a few ways to protect your proprietary strains of cannabis. So first, you have utility patents. And as detailed in the section above in this video or before, cannabis plants may be protected under utility patent when an entrepreneur can demonstrate that the plant has a specific chemical profile. That's that new and novel thing we were talking about earlier. But next are plant patents. And a plant patent can be applied for any instances of asexually reproduced plants. The invented strain must be new and non-obvious. And the plant patent must be applied for within 1 year of the first sale. So for a cultivator that sells a strain that, on March 1st, 2019, they must apply for the patent before March 1st, 2020. And plant patents are valid for up to 20 years of protection. The USDA provides plant variety protection certificates to give owners exclusive rights to seeds of a new crop for 20 years, but this option is currently not available for cannabis operators. So I strongly recommend working with an IP lawyer to start protecting your proprietary cannabis strains. The patent process is extremely involved. It's not just like one document and we're all done. But as the market continues to grow, it will be crucial for you to differentiate your business from the competition by securing very detailed and well-prosecuted patents. It's just an amazing thing, an amazing difference between someone who self-writes versus a law firm that writes beautiful claim language that's broad enough to cover and protect your actual little square in this business landscape. Now we have cannabis design IP. So design patents and copyrights are the most common forms of protection for cannabis design IP. And design may refer to the way that a vaping device looks, or software, or any artistic expression for, say, a website or a t-shirt design, for example. Okay, so design patents protect the look of functional items, specific design elements, or details the way a product looks. So think about the home button for the iPhone 4. That's an example of a design patent. Now, design patents last for 14 years and can cost at least $2,500 for that patent. So copyright protection can be used for artistic expression, again, website design, or cannabis-related product design, things like that. And design patents are more broad than a copyright, therefore in some instances may be more easily enforced than a utility patent to protect your design and your ideas. Last but not least, let's talk about protecting your cannabis business secrets, okay? Trade secrets are something that every cannabis entrepreneur should aim to protect. You gotta hide the secret sauce. You can't just let anybody see the recipe or see how you do your business, all right? Now this might include your customer list, your business plans, your secret recipes that are older than 1 year and can't be protected by a utility patent. Now, most states offer some ways to protect your trade secrets by using, NDAs or non-disclosure agreements with your employees, or online authorized and unauthorized data uses of those informations, network security, other on-site security measures. There's so many ways to protect your business. So the IP not necessarily can be, protected under a patent, but you can take extra security measures to make sure everything stays within the four walls of your business. And it's best to speak with an attorney who can help you protect your business secrets depending on the size of your operation and the specific state that you're working within, because regulations change from jurisdiction to jurisdiction. Now, I hope that this video has brought you some value and gave you some context around how to protect the intellectual property of your cannabis business. So if you want help in finding a trusted IP attorney who's done this before that can protect your cannabis business, then please get in touch with GreenGrowth CPAs by reaching out to us via our website at greengrowthcpas.com or give us a call at 674-9050. Have a great day, and we'll talk to you soon.